All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and its honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning. Welcome to the virtual District of Columbia Court of Appeals. We are starting about 15 minutes late. I apologize to you for that. There was a technical glitch that delayed us. We have 3 cases on the calendar this morning. The first case is Simmons v. Simmons. Counsel, we'll hear from you.
Good morning, Your Honors. Patrick Merkel on behalf of Robert Simmons. This matter is before Your Honors in respect of defining marital versus separate properties. And the issue comes because Mr. Simmons had a property in Jersey City, New Jersey for 11 years prior to his marriage, which he had while he was married, and before that, he was working in the Foreign Service, specifically Agency for International Development. And he had a manager in New Jersey for all that time. He never actually went up to his property and did anything, excepting on a very occasional inspection basis. And he continued that arrangement after he was married. What we found is that Judge O'Keefe determined that because Mr. Simmons had changed the title on the property from his own personal name, his name individually, to his name, to a corporation that he had organized through the up in New Jersey to hold title. As he testified in court, he said he was doing that to immunize himself individually and consequently his new family from any potential liability. He used the term slip and fall in his testimony. And judge said, well, it looks like you spent $100 of family money to set up this corporation. Therefore, it was a marital property, and therefore you commuted this property or transmuted this property into marital property by acquiring it through the corporation. Well, I think that there are a lot of times people will change names on accounts. We've even seen where for loan purposes, separate property is now titled in tenancies by the entireties, and the separate nature of the property is still preserved upon divorce if there was no gift intended and it's shown that no gift was intended. So I think this was a clear error, a plain error on the part of Judge O'Keefe.
Well, let's think about that for a moment. When you do something to change legal status, it has consequences, doesn't it? For instance, in this particular case, the fact that it became a corporation shielded him from personal liability on the corporate debts. And a moment in time, a corporation was formed, an LLC, with, let us assume, marital property. So the marriage now has an asset, a corporation, that exists independent of Mr. Simmons and its marital property. Then Mr. Simmons conveys to this corporation his property. Why doesn't that become marital property?
Well, the character of the property itself is still owned, is still Mr. Simmons's. Mr. Simmons is the owner of the corporation. He's also the sole member of the LLC. The de minimis nature of the changing of the ownership of the property was, it's not even the tail that wags the dog. It's the toenail that wags the dog here. And I understand what you're saying, Your Honor, but the fact of the matter is the marital corporation that has acquired this property has not done it for any value. This is 100% of a non-taxable type of transfer. It's not going to be recognized by any entity like the IRS as a taxable event. And all we've done is change the name on the account. That's
all he did. What happened was, at one point, he owned the property. At the next point, the corporation owned the property.
and he owned the corporation.
I mean, he happened to be the sole owner of the corporation. But the fact of the matter is that the legal ownership has now been changed from his name into the name of the corporation. So it seems to me the crucial question is, was that corporation marital property or was it separate property?
And I think the answer is that it was very much separate property.
Why is that?
And that,
Well, those were used.
I'm sorry. Judge Stedman, were you saying something?
Yeah, I said, why is that so if marital property was used to create the corporation?
Well, that, of course, is what Judge O'Keefe presumed. I think among the facts of the trial is that the plaintiff never assigned any value to the Jersey City property as a marital interest. They never came in and said, this property is worth X. In fact, Judge O'Keefe did some back of the envelope calculations to arrive at a value of the property based on a $500,000 loan that had been extended as a line of credit back in 2005, before the property was converted. I mean, he came from Kazakhstan with his new wife. One of the first things he did after settling into Arlington, Virginia, was to obtain this $500,000 line of credit on the property up in New Jersey. Toward the end of that year, he instructed his manager what he wanted to do to put it into a corporation. And since everything was being handled by a trusted property manager, Del Forma Real Estate up in Jersey City, everything was done remotely. All Mr. Simmons had to do was sign papers, and there was no evidence that was presented that says, hey, look, here's the check from the marital account. Here's the emails showing that he's applying payments from his credit card that's a family credit card. In fact, after the fact, I realize it's too late now, after the fact, I've got the email that shows that he did it exactly the correct way by having everything done up in New Jersey. It wasn't an issue at trial until Judge O'Keefe made it an issue in his order. That's the point. Tatiana Simmons never claimed an interest in the Jersey City property as marital. What she was trying to do was claim that it had been some sort of gift to create it in the name of a corporation that sounded obliquely like her own. So for the judge to take the payment of the $100, which was the $100 of the consideration, not the cost of setting up the corporation, that was the mention in the deed, not the, there was never any evidence of what Mr. Simmons paid to set up the corporation.
Let me ask you this question. Is this correct? There is no evidence in the record one way or the other as to where the money came from to establish the corporation. Is that a correct statement?
I think,
Well, no, for
I
sure.
think that the reason that I would say there is, I think there is evidence. And I think the evidence is that everything that happened in New Jersey happened with the money in New Jersey, with the Mr. Del Formo in charge of the rents, the tenants, the cash flow, the expenses.
Well, the problem is that the charge is very dubious in Mr. Simmons' testimony. Let's start with the proposition.
We don't have the best. I got to tell you, I understand what happens when an individual is a business failure. And it's the last thing he's going to admit.
Let's talk about the legal issue. If there is no proof, one way or the other, do you have any views as to how presumptions operate in this situation? In other words, who had the responsibility to show that where the money came from to establish the corporation?
I believe that in order to show that it was separate, commuted to marital, it would have been on the part of the plaintiff to show that the money came from marital funds.
That's the question, isn't it?
Yes, because if Tatiana, again, Your Honor, this is an issue that was created by Judge O'Keefe in his order, not something that they argued in closing, not something that they took extensive testimony about, trying to show, nobody ever tried to show that Jersey City property was marital. If they had, they'd have had an appraisal, there would have been some evidence of its value. You can
I didn't quite get it from your brief, but I hear what you're saying. What you're saying is the trial judge erred by even addressing the question of whether or not this was separate property or marital property, because no claim was ever made by the wife that it was marital property, and therefore the trial judge had no business even investigating the issue. Is that the point? Is that what you're saying?
I'm not saying that the court can't sua sponte do things. Of course it can. But the problem is that if he wants to look in behind the formation of the corporation and make presumptions about where the money came from, he really has to have some basis other than not liking Mr. Simmons and feeling that Mr. Simmons is not a reliable witness for doing the work that Mr. Simmons represented. That he were totally, for the most part, he was totally on board. What he wasn't good at was admitting that he was a business failure.
Mr. Merkel, let me ask you, before your time is up, how consequential is this issue, given the fact that the judge, at the end of the day, awarded the New Jersey property entirely to Mr. Simmons?
Because by determining that that Jersey property was marital, that took the $500,000 that was borrowed against the property, even though the loan had been extended while it was clearly separate property, but the money wasn't obtained until after, according to Judge O'Keefe, it was now marital property, and that made the assets that were acquired downstream marital property as well. And the property on Michigan Avenue, had it not been marital property determined, then the most that Tatiana Simmons would have had as an interest in that property would have been an equitable lien on Mr. Simmons's separate property, and he would remain entitled today, because the court wouldn't have the authority to take separate property and transfer it to the other spouse unless it were shown that it was marital property. If it's a marital interest in separate property, you get a lien, and that equitable lien is then enforceable. It's the lump sum award. But
Is it clear from the record that the money used to acquire the Michigan Avenue property was derived from the New Jersey property?
absolutely, it was 100% purchased with proceeds from that New Jersey property. It was the first loan. It was the first advance on the line of credit taken in 2008. He judiciously waited for the market to crash. Whether he knew that was happening or not, it timed out perfectly, and he bought a property at a substantial savings using the money that he had acquired on a loan, which was based on a price in 2005 when things were nuts.
We have used up, I'm sorry, go ahead, Judge Thompson.
I was just going to ask Mr. Merkel if there's anything more he wanted to tell us on the income imputation issue.
Well, here again, you've heard me allude to Mr. Simmons as the world's worst liar when it comes to admitting that he's a business failure. What he does is he dances around the issue, but he clearly presented how he had incurred over almost $2 million of debt during his fairly short marriage. And that translated into the lifestyle that Judge O'Keefe said must be income. But it simply was.
Can I ask a question?
Go ahead.
If in fact the New Jersey property was marital, then the Minnesota property is going to be marital as well, isn't it?
Michigan, yes, that's exactly what Judge O'Keefe ruled.
So if it turns out that the New Jersey property is marital, then there's no real issue as to the Minnesota property. If it's not marital, if it's separate property, then I think we're going to hear some discussion about whether or not, in fact, the sole purchase price came from the New Jersey property or not, because I think the brief of the wife says that some of the money came from marital property.
For the renovations.
It's an interesting question. What if part money came from marital and part of it came from separate? What's the property treated as?
Right. Yeah, I think it's a fair statement on the renovations, that the renovations money appears to have been marital.
Okay.
Let us, we will give you a few minutes in rebuttal. Let us hear from Mr. Simmons' counsel.
Thank you, Your Honors. Good morning. My name is Julie Grice. I'm with DLA Piper on behalf of Appellee Ms. Tanya Simmons. I'd first like to address the issue of equitable distribution of property with respect to 141 Sussex Avenue. As a preliminary matter, a trial court is accorded broad discretion in determining parties' property rights incident to divorce. And as long as the trial court properly considered statutory guidelines and all the relevant facts and circumstances before the court, the trial court's rulings are not to be disturbed on appeal. And in this case, Judge O'Keefe did precisely that. He looked at the statutory factors enumerated under 16.910B, and the detailed discussion of those factors is found at pages 71 to 75 of his opinion. And importantly, Judge O'Keefe also took into consideration all of the testimony and evidence presented to him at trial. And I think Judge Tidman, Your Honor, pointed to a critical story here with respect to 141 Sussex Avenue. And that is there are three very distinct points in time relevant to whether or not 141 Sussex Street became marital property. The parties were married in October of 2005, and then thereafter, Mr. Simmons formed Zukin Holdings Corporation. Shortly thereafter, in 2006, he transferred ownership of 141 Sussex to Zukin Holdings Corporation for, albeit minimal consideration, but $100 nonetheless. And then a third point in time is when Mr. Simmons transferred the property to yet another corporation, which he formed after the marriage, Zukin Holdings LLC, and again transferred title and ownership to that corporation. And Your Honor's asked a good question. Who bears the burden of demonstrating that these corporations were in fact marital property, or excuse me, were separate property? And a party seeking to show that property is separate property, it's his burden to make that showing at trial. And Your Honors, Mr. Simmons simply failed to meet that burden. He presented no evidence at trial, no documentary evidence, no testimony that the funds used to incorporate either of these entities were anything other than marital funds. He also provided no testimony and no evidence regarding the consideration that was paid for these two entities. And so having failed to meet that burden, the court was not clearly wrong in determining that these entities were formed using presumptively marital funds, and thereby transforming the 141 Sussex Avenue property.
Do you agree with Mr. Merkel, though, that the matter of who owned the New Jersey property was never placed in issue during the trial?
No, Your Honor, I don't agree with that. On cross-examination, we raised the issue of the Zukin Holdings Corporation and Zukin Holdings LLC transactions. And that was the first time that had been brought up on trial, in large part, as Your Honors may have seen in the record. The existence of these entities were not disclosed in discovery. Interrogatory responses despite calling for that information. And so trial counsel on cross-examination brought up these issues in order to determine whether or not the 141 Sussex Street property was in fact marital property. And on redirect,
Right. You're saying it was litigated as to whether the marital property, excuse me, the New Jersey property was marital or separate?
that's correct, Your Honor. We addressed this directly on cross-examination, and Mr. Simmons' counsel was afforded the opportunity.
Whom?
I'm sorry, Your Honor, I didn't hear that.
I'm trying to understand. This is an argument that is not brief, but it looks like it might be very important. Was or was not your client making the claim that the New Jersey property was marital, and therefore it was the obligation of the husband to show that it was separate? Was it raised or not? And if so, where?
That's correct, Your Honor. It was raised on cross-examination in questioning Mr. Simmons about the transfer of this property to these.
Look, there's 10 days of testimony. What I'm asking,
Yes, Your Honor.
where in the 10 days of testimony are you going to make a showing that this was a contested issue?
Yes, Your Honor. The cross-examination of Mr. Simmons that deals with Zukin Holdings Corporation and Zukin Holdings LLC was on January 11th, 2018. So it was towards the end of trial.
After that cross-examination, was the subject ever mentioned again in submissions to the court and pleadings and proposed findings and conclusions or anything like that?
Yes, Your Honor. It was raised in Ms. Simmons' proposed findings of fact and conclusions of law that the transfer of the property rendered the 141 Sussex property marital property.
Now, let me
And are
ask
you
you a
hanging your hat on the funds used to establish the corporation? Is that what makes the property marital, that it went to a corporation for which the incorporation money came from marital assets?
Yes, Your Honor, in part. That's part of the puzzle here. So the funds.
But what's the rest of it?
Yes, Your Honor. The funds paid as consideration to transfer the property from Mr. Simmons in his individual capacity to Zukin Holdings Corporation and Zukin Holdings LLC.
The $100 consideration makes it marital property? I mean, that was income realized during the marriage, but it was income from, if we assume that this started out as individual property, and if we further assume that nothing else changed it, that $100 in consideration doesn't become a marital asset, does it?
Well, I think, Your Honor, the critical point here is Mr. Simmons' burden to show that these funds were in fact separate funds. And he simply did not make that showing. The record below does not demonstrate that the funds either used to incorporate the entities, transfer the property.
Suppose the record showed that the New Jersey Management Company used the rent money from the New Jersey property to do all the incorporation work. Let's assume that for a moment. But that Mr. Simmons used his cell phone to tell the company in New Jersey to please do this. And so he used some minutes of time on his cell phone, and I don't know, let's further assume that he had an overage, so he had to pay extra for these minutes. The fact that he used marital assets to pay his cell phone bill, does that mean that the property became marital property? Because in that sense, he used marital assets to do this transfer?
It's an interesting question, Your Honor, and I'll do my best to address it directly. But here what you have is Mr. Simmons transferring marital property to a corporation that was formed after the marriage. And to answer your question, whether any amount of money of marital funds the property renders it marital property, I'm not sure. But here we have absolutely no evidence that either of these funds, any portion of them, were anything other than marital funds. And so I think what we're faced with here is a little bit different than the scenario that Your Honor posited.
Well, I wonder if that's really true. Suppose we think, the papers say that nominal consideration was paid for the property, $100. put a set of peppercorn or $10. We have, in the real world, some reason to think no $100 was ever actually exchanged, that's just a formality of the documentation. And we also have reason to suspect that if $100 was exchanged, it was a paper transaction handled by the company, the property management company in New Jersey. We don't know, but that's certainly reasonable to suspect that. And similarly, as far as the formation of the corporation was concerned, we have no real reason to think that marital funds were used to form the corporation or the LLC. It could be that they were just formed entirely by the property management company, or perhaps by Mr. Simmons, without digging into marital funds. Given that if something significant is really at stake here, and given the inadequacy of the record, I just wonder whether the appropriate course would be to remand for the trial court to expand the record and determine what the facts actually are, if we think they make a difference. What do you think of that?
Your Honor, respectfully, I don't think that remand in this case is necessary. There was extensive opportunity for Mr. Simmons to provide evidence regarding these transactions. There were significant financial records presented as evidence at trial, and extensive testimony taken.
Well, when you say that, let me just interrupt you if I might, and just
Yes,
ask you, when you say that, did anybody actually ask Mr. Simmons during cross-examination where the $100 come from? Was it paid? Did anybody actually ask him during cross-examination, where did the money come from to set up this corporation or the LLC? Tell us about the details of that transaction. Or was there any, I gather there was not, any discovery into those questions? In other words, I'm wondering whether any of this was really explored when you say it was raised on cross.
I don't believe the question precisely where the funds came from was raised on cross. But again, Your Honor, when a party is seeking to demonstrate that property is separate property, it's his burden to make that showing at trial, not Ms. Simmons' burden to make that showing at trial. And Mr. Simmons' trial counsel did, on redirect, address these various transactions, but did not raise this issue and therefore did not meet their burden on appeal. Excuse me, on
Mr. Merkel says that the parties made no effort to value this property. And that seems to weigh in favor of a conclusion that your client was not really thinking that this was marital property to be distributed. What's your response to that?
In terms of the valuations, Your Honor, I think it's important to keep in mind, Mark Kessler appraised all of the properties at issue, and Ms. Simmons just simply did not have access to the documents or information sufficient to, I think, make that appraisal. And there was testimony and evidence presented regarding the mortgage that was taken out on, the line of credit on the 141 Sussex Avenue property, and then taking into consideration the purchase price. So I think there was evidence in terms of the value of the property, although you're correct, Your Honor, Ms. Simmons did not do a formal appraisal of that specific property.
Suppose we or the court were to conclude that the New Jersey property was separate property. What would the consequences of that be? The practical real world consequences be in this case for the distribution of the remaining property?
Well, of course, the 141 Sussex Avenue property would remain in Mr. Simmons' separate title. But I don't think that it impacts the remainder of the distribution of property. And I'll turn now to the 23 Michigan Avenue property. And I say that for a few reasons. Even assuming the 141 Sussex Avenue was determined to be separate property, what we have here is a property acquired after the marriage using borrowed funds. And line of credit that was taken out on the 141 Sussex Avenue property was for $500,000, and that was used to make a cash purchase towards 23 Michigan Avenue. But thereafter, you had Mr. Simmons taking out a mortgage on the 23 Michigan Avenue property and then taking out another line of credit against the property. And the trial court heard testimony on sort of the payment of the mortgage on 23 Michigan Avenue and found Mr. Simmons' testimony on that point to be not credible because the rental property or the rental income, excuse me, from 23 Michigan Avenue was sufficient to pay the mortgage for 23 Michigan Avenue standing alone. And so it wasn't, the record evidence did not show that the funds from the 141 Sussex property.
But if the, right, but if the money used originally to purchase the Michigan Avenue property was separately derived, then the rental income from that property presumably would be separately derived too. So whether we look at the, so even if we think that the rental income could just as easily be viewed as the source of the mortgage payments, I don't know if that gets you where you want to go, does it?
Well, even so, if the 141 Sussex Avenue property was separate property, and then
Excuse me, was what, we've been having, by the way, just so you know, we've been having, or at least I've been having, some problems with the sound of your argument. You fade in and out for some reason. So I don't know whether that's a problem with your machine or not, but we've generally heard you. But I apologize for asking you to repeat yourself.
oh, my apologies, Your Honor. I apologize if my computer is acting up, but I'll try and address your question. On
It's gotten worse, sorry.
is that any better?
Is it just me or are other judges having the?
Same problem here.
Same problem, although it seems to get, when you move back and forth, there are moments when it's better. I don't know if you're moving away from the microphone.
Let me try.
Yeah,
That was good.
Is that better?
yes.
Sorry, yes, that's better. Sorry to make you uncomfortable, but.
Oh, no,
I
not
hear you.
not at all. It's the sort of the curse of these remote times. But let me try and sort of reorient myself back to your question, Your Honor. If the 141 Sussex Avenue property was separate property, and therefore the line of credit that was taken out to acquire the 23 Michigan Avenue property was also separate property. I believe you asked whether or not the rental income from 23 Michigan Avenue would be separate property as well. Was that your question, Your Honor?
Yes, yes, you put it better than I did. Yes.
Well, I think there are a few issues there, Your Honor. The first is that this isn't under the statute sort of the normal situation where a property is acquired in exchange for separate property. In other words, this wasn't a situation where Mr. Simmons sold the 141 Sussex Avenue property and then cleanly used the proceeds of that property to then acquire 23 Michigan Avenue. Instead, what we have is borrowed funds on the 141 Sussex Avenue property, and then an additional mortgage being taken out on the property. And so it's what we have is just a sort of a rotating series of sources of the funds. And it was, again, Mr. Simmons' burden at trial to demonstrate by preponderance of the evidence that all of the funds used to acquire 23 Michigan Avenue were in fact separate funds. And I would just briefly point the court to Judge Thompson's decision in the 2013 decision in Araya versus Kalita, where the court did note that the husband in that case failed to demonstrate by preponderance of the evidence that the funds used to acquire the property after the marriage were in fact separate funds. And I think that is similar to the situation where we have here. It was Mr. Simmons' burden to make that showing, and he simply failed to do so.
You get the facts straight. They want to buy the Michigan property. I don't know what the purchase price was, but at least $500,000 was used from the line of credit. And that, let us say we're assuming, was separate property. Now, I guess the argument would be that at that point, it is still separate property. But then what happened subsequently to that?
Yes, Your Honor.
Separate property at the point where they bought the property. There must have been some down payment or something. Couldn't just, was the $500,000 the total purchase?
Let me see if I can clarify this for Your Honor. So there was a $500,000 line of credit taken against the 141 Sussex Street, New Jersey property. And from that line of credit, Mr. Simmons used $199,000 or a $200,000 transfer from that line of credit to make for the purchase price of 23 Michigan Avenue. And thereafter,
I mean, that was the total purchase price?
I believe, maybe not quite, but for the most part, yes, I think it was maybe a couple $1,000s difference in the purchase price.
Okay, so it was a cash deal to buy Michigan Avenue.
That's correct, Your Honor.
Clearly separate property at that point. Okay, then what happened?
Then subsequent to that cash transaction, because the cash was used from borrowed funds, essentially from the line of credit, Mr. Simmons took out a mortgage through Wells Fargo on the 23 Michigan Avenue property, I believe in the amount of $500,000. And then thereafter took out a line of credit against the property through PNC Bank. It was a home equity line of credit. And he testified that the line of credit, at least in part, was used to make very extensive renovations to the home, including renovating and gutting the kitchens, redoing the bathrooms, finishing the basement. And so you have sort of a series of borrowed funds related to this specific property. And I would just reiterate to the court that it was Mr. Simmons' burden to show that the funds used to actually acquire this property were in fact clearly separate funds, and he failed to meet that burden. And so for that reason, Judge O'Keefe's findings in the trial court below were not clearly erroneous. And I know I've used up all of my time, but if I may just briefly address the issue of child support.
Okay, very briefly, go ahead.
Very briefly. So, Your Honor, I would just like to address the issue of the imputation of income to Mr. Simmons. And I'll make two very brief points on that. First, I would again point the court to the opinion in Araya versus Kalita, where this court specifically held that a trial court may impute income to a parent where it is necessary to arrive at a realistic assessment of the parent's ability to pay. And that's precisely what Judge O'Keefe did in this case. There was significant credibility issues with respect to his testimony about his income. And so the judge was left with very competing pictures of his income, both in terms of his tax returns, as compared to the very comfortable lifestyle that he had testified to. And so Judge O'Keefe appropriately imputed the owner's draws to Mr. Simmons as income. And I would also just highlight for the court, appellant takes issue with the owner's draws being imputed to Mr. Simmons as income, arguing that it was inequitable, unjust, and essentially a double counting. But what appellant fails to acknowledge is that the amount that Judge O'Keefe found to be a reasonable indication of his income was almost precisely the exact same amount that Mr. Simmons himself had represented to a federally insured institution was his personal income. And so he can't, on the one hand, represent that that is an accurate picture of his income when it serves him. And on the other hand, in this appeal, argue that the trial court's findings were an abuse of discretion in essentially reaching the exact same amount of income as to him. And so with that, Your Honors, unless you have any additional questions, I would just respectfully ask that this court affirm the trial court's judgment below with respect to the 141 Sussex property, 23 Michigan Avenue, and the imputation of income to Mr. Simmons for purposes of determining child support. Thank you.
Thank you. Mr. Merkel, we'll give you 3 minutes. Mr. Merkel, I think your mute is on.
The point you made about the rental income, whether it came from to pay the mortgage on Michigan Avenue, whether it came from the New Jersey property or Michigan Avenue, either way, if the acquisition, which it was, and that was testified to, was 100% purchased by the LOC advance on the New Jersey property. As long as the New Jersey property is set aside as Mr. Simmons's separate property, and certainly the line of credit was, although the advance on it is now disputed by the appellee that by the time the money was borrowed, now it was a marital asset by changing the name on the property. I mean, essentially what we see is Mr. Simmons being punished for insulating his family from potential liability on the property by having set it up in a new name. It's kind of chilling for future spouses to do that, or make sure that when they do so, they have every single record. You know, it's the first thing he did in his marriage. He wasn't thinking about divorce. He was thinking about protecting his family when he set up that corporation. And then later, as he testified, he allowed his testimony was that they set up the LLC for him for tax purposes. The record shows that Del Formo is the registered agent. It's his registered office for the LLC. Now, as far as the income to Mr. Simmons is concerned, I'm just shaking my head as a sole practitioner myself. I know how you have to show a bank that you don't really need money in order to borrow it. But at the same time, you wouldn't be there borrowing it if you didn't need it. And here we have Mr. Simmons, who has been borrowing money, putting it into his company, and taking the draws out, being assessed as those draws being income, when we know that the real income that Mr. Simmons enjoyed was nothing. He was running up his debt incredibly in order to maintain this lifestyle that he had for himself, his wife, and his kids. Did
he ever make payments on that debt?
Yes, he was able to either borrow money to continue to make payments, or he did have an ongoing business. His AMI was an ongoing business, but it involved. I think his testimony was that he would get contracts where he would hire people to do the work, and then he would be able to take whatever was left after he paid for the services of his staff to perform the obligations of the contract. He did not make a lot of money during the marriage. His business had one huge successful contract, and that was it. He lost his section. He was an 8A contractor, you know, the small disadvantaged business. Mr. Simmons being African American, I don't know if that's a factor for the small disadvantage, but the bottom line is he lost that after 8 years, and then he was no longer able to get the contracts.
Okay, well, I think we have heard the arguments, and the case will be taken under advisement. Counsel, thank you both.
Thank you, Judge.
Thank you, Your Honors.
Judge Stedman, nice to see you again. My dean at the graduate school at Georgetown from 1980.
Long time ago.
Isn't that something? That's great. Take care, all.
We'll call the next case. Mr. Green?
Council need to exit.
Not exiting.
Judges, we're bringing in the next counsel.
Thank you. Okay. Mr. Green, are we ready?
Yes, we are ready. Counsel, you ready?
Yes.
Yes,
Uh,
yes.
Okay, the second case on the calendar is John Connor versus United States. Counsel?
Good morning, Your Honors. Mitchell Schwartz on behalf of Mr. John Connor, the appellant in this matter, and I'd like to reserve 3 minutes for rebuttal. May it please the court. The collateral estoppel doctrine embodied in the double jeopardy clause of the Fifth Amendment prevents relitigation of a required element in each of the 3 cases before the court now. And therefore, we request that this court reverse the lower court's denial of Mr. Connor's motions to dismiss. On December 18, 2019, John Connor was tried by the United States government for contempt under DC Code 23-1329 for violating a March 25, 2019 stay-away order for his alleged presence at the Anacostia Metro Station. That same day, a judge of the DC Superior Court acquitted Mr. Connor of contempt and stated in his findings of fact that the government failed to prove beyond a reasonable doubt that the March 25th order is sufficiently clear and specific to serve as a guide for Mr. Connor's conduct. Now, underlying Judge Kroll's findings, Judge Kroll's overarching finding, were 2 separate findings that each gave preclusive effect. First, and I'll take them in turn. First, that just the term Anacostia Metro Station is unclear as to specific location. And that is whether it includes conduct that is outside of a physical train station at the entire Anacostia Transportation Campus. And Judge Kroll referred to this whole area as a vast area and stated that the area Mr. Connor was found in was not the train station itself. It was not the actual metro. And from just this sentence, it's clear that Judge Kroll is equating actual metro to the train station. And from reviewing the transcript, this makes sense because not only was this the exact argument by defense counsel.
The other 3, the 3 before us, how many of those occurred within the Anacostia Metro Station?
And so one case, according to the government's proffers, one case, 0266, is within the physical train station, and the other 2 cases, 267 and 268, according to proffers, all rely on conduct solely outside of the physical train station. And so I'm the first preclusive.
So why would 0266 then be precluded? Why would prosecution in that case be precluded? Because you're quite right. I looked at the argument by defense counsel that preceded the court's ruling, and defense counsel is very clear that he thinks Anacostia Metro Station means the train station itself. The trial judge seemed to agree. And it does seem that the context of his ruling makes clear that what he meant was that the stay away order wasn't a clear guide to conduct outside the train station. So why should 0266 be precluded?
Yes, Your Honor. So 0266 should be precluded because of the second finding underlying Judge Kroll's overall statement that the stay away order was insufficiently clear and specific beyond a reasonable doubt. And so I'm happy to talk more about the difference between inside and outside the station and what underlay that, and I can return to it. But just to move on to answer your exact question, Your Honor, it's clear that from Judge Kroll's findings that there was something else underlying his issue and concern with the stay away order. And upon reflection and review of the government's brief, actually, this is where I agree with the government's brief in part, because the government states that Judge Kroll found that if Mr. Connor was there to take a bus or train, the order did not clearly and specifically guide how he was to do so. And I think that's actually right. Looking at the transcript, it's undeniable that Judge Kroll went on in his findings of fact to say, quote, if it wanted to allow him to take a bus or a train, it could have provided him a very specific guide to do so. Put another way, Judge Kroll found that the order was not sufficiently clear and specific on how Mr. Connor was to conform his behavior if he was present to take a bus or a train. And that factual finding has preclusive effect, for as the government argues, Judge Kroll found that the order failed to serve as a guide for how Mr. Connor was to take a bus or a train. And so,
why does the order have to serve as a guide for that purpose? If he is there to take a bus or a train, that's a factual question. The government would have the burden of proving that he is not there for that purpose, beyond a reasonable doubt, I suppose. And the government might or might not be able to prove that was his intention and purpose. But why does the order have to tell him, all right, if you want to take a bus or a train, here's how you have to do it? To be clear, he is not to go to that station. He is to stay out of that station, except that if his purpose in being in that station is to take a bus or a train, okay, you're not in violation of my order. Now, you may have difficulty convincing somebody that that's your purpose, but I don't have to spell out for you in my order how you should go about doing that. I've told you how to behave. And if the government proves what your purpose was, then, you're in violation of the order. What's wrong with that thinking?
Well, Your Honor, there's nothing intrinsically wrong with that statement. The difference here, though, is that Judge Kroll made a factual finding that, as a fact finder, he did not believe that this stay-away order, beyond a reasonable doubt, served as a guide for Mr. Conner's conduct because it didn't tell him how to conform his behavior if he was there to take a bus or a train. And so, because of that,
If he's there to take a bus or a train, he's not misbehaving. He doesn't have to conform his behavior to anything. If he is there to take a bus or a train, then he can be there. There's no violation of the order. Now, he may have trouble convincing people that that's the reason he was there, but that's a different question.
yes, Your
It
Honor.
seems to me.
Well, to Judge Kroll, as the fact finder, and not making a legal conclusion, just as the fact finder, it seemed Judge Kroll, in his findings of fact, spoke about this carve-out provision and the issues with the carve-out provision, and then went on to say that the stay-away order itself could have provided him a very specific guide to do so if it had wanted to allow him to take a bus or a train. There's no other reason for Judge Kroll to have said that unless, as the fact finder, he had an issue with the stay-away order and could not find that whatever the stay-away order was supposed to do, provide this carve-out provision, on its face, it could not. And so all this argument, and just to return to Judge Glickman, what the concern you had just raised, I just want to emphasize, as all your honors are aware, that this just comes down to a factual finding by Judge Kroll, and whether Judge Kroll's finding, whether this court agrees with whether it was factually correct or factually incorrect, is immaterial. Just whether that finding shares an issue of fact in these three cases on this appeal.
Actually, I'm not sure it matters whether we frame it as an issue of fact or as an issue of law, but I take your point.
And yes, Your Honor. And so I just say that these cases, this decision only impacts these three cases, and the exact same identical stay-away order could be related with any other defendant in the entire country in the DC Superior Court, and this decision and Judge Kroll's factual finding would have no effect on those cases. It only serves because of the shared parties and the factual finding in the November 18th case. And just to close out why, it makes sense that Judge Kroll would have had this concern with this carve-out provision, just reviewing the trial transcript. Judge Kroll, in closing argument, defense counsel argued that even if Mr. Conner had committed a crime by selling a cigarette, it's not a violation as long as he was at the location with the intent of taking a bus or train. And so, presented with this argument, I think it's easy to infer that Judge Kroll clearly had some issue with, well, how am I supposed to decide whether he's present there when he's if he's selling a cigarette, or if he's talking to someone, or if he's doing jumping jacks, if the order says that he's not violating it as long as his purpose is like a bus or train. Yes, Your Honor.
There was no testimony how long he had been where he was. And he perfectly well could have been there getting ready to cross the street and catch a bus, right? Isn't that right?
Your Honor,
other case, there's testimony that he had loitered for a long time.
Right.
And that's pretty good proof that he wasn't there to catch a train or a bus. I just can't see why you think that one case is like the other.
Well, Your Honor, there was no testimony about length of time at the December 18th trial. So no testimony of whether it was a short period of time or a long period of time. And the testimony was that he was on Metro property. It was conceded by Mr. Connor. The officer's testimony was unimpeached that Mr. Connor was present on Metro property. And so in terms of period of time, there was no period of time in the December 18th case. And so the shared issue here is for Judge Kroll, if the third case, the one on appeal 266 that involves presence inside a physical train station, Judge Kroll's concern that underlay why the order wasn't sufficiently clear and specific still exists. It's if the order intended to allow him to take a bus or a train, it could have provided him a very specific guide how to do so. And Judge Kroll found that it hadn't provided that guide. And so it's the same problem with the stay away order, both in the December 18th trial and
All
any
this discussion shows why these factual differences are very important. And you can't just apply estoppel by saying, oh, well, it's just the same in all four cases. I mean, look how much time we've spent talking about, oh, how long was he there? Where was he? What particular things? I don't understand why the trial court, Chief Judge Moore, wasn't correct in his analysis.
well,
First, the one who more or less conceived he was in the train station.
yeah. I'm sorry. I just want to make sure you finished your question, Judge Stedman. So
Trying to figure out how the argument goes, that's all.
yes, so it's I would take a step back and say it's the classic example of the uniqueness of the collateral estoppel doctrine embodied in the double jeopardy clause. That the court, if the court were to take every case and look at every collateral estoppel issue by the most minute facts, collateral estoppel would never apply in any case, because the classic example of Ash, the robbery, and in the first case, an acquittal of robbing one of the individuals at a poker game, and the Supreme Court saying in subsequent cases it's collaterally estopped because the issue was in the first case whether he was present or not. Now, if instead, if you had just parsed that out, it could have been if he was present and standing 10 feet to the right from the first case, instead of he was present and standing 10 feet to the left. And so the reason I that example is because you're going to always be able to parse out the most minute of differences and distinctions. But I think at core, if you look at the findings of fact in the December 18th trial, when Judge Kroll said that he could not find that the order was sufficiently clear and specific beyond a reasonable doubt, that applied to the stay away order for those two underlying reasons. One having issue with the inside versus outside, which we talked about, and the other having to do with Judge Kroll's a fact finder simply determined that the stay away order couldn't, at its face wasn't clear and specific because it failed to provide a guide of how Mr. Connor was to perform his behavior. And again, whether this court thinks that was the correct factual conclusion or the incorrect factual conclusion doesn't matter. All that for this court and for Judge Morin to have decided below was whether there was a shared issue between December 18th and any of these three cases, Your Honors.
I wanted to ask you, if I
Like to sit down.
may I just ask this question? I'm sorry. I wanted to ask you a question just about the record in these cases. And I apologize because I cannot remember which of the three cases I saw this in, but in the record in one of them, there is a stay away order that has a map attached to it. What is that doing in this record?
Yes.
Why is that there?
So it's there for, I'll just take a step. There is an amended stay away order that was entered after all of these three cases on this appeal today. After the arrest in these three cases, there was an amended stay away order that the government filed with the map to basically, I guess, address Judge Kroll's concern. So it has no impact on these three cases because that amended stay away order was entered after all these three cases came into existence. So
Yeah, I thought from the date that was so, but I couldn't tell from the documents around it what it was attached to. So I couldn't figure out why it was in the record of these cases.
I think just because there were multiple cases and the original underlying case that the March 25th order had been entered in has been resolved. So there was no original case to file the amended order in. So it was just filed and for whatever reason in, I believe it was 2019 CMD 9641, just so that it was filed in a case. But it has no effect on these cases other than to say, the government later filed an amended stay away order with a map, clearly to address concerns that were raised in the December 18th trial. And it is, of course, our position that any prosecution involving this new stay away order, any decision today has no effect on that. It's a different stay away order. The issue is now different, whether the new stay away order serves a clear and specifically serves as a guide for this conduct.
Thank you. We'll give you a few minutes in rebuttal. Let us hear from Mr. Hand.
Thank you, Your Honor. May it please the court. Brian Hahn for Appellee of the United States.
I'm sorry.
That's happens all the time, Your Honor. In this case, Judge Kroll did not decide that the stay away order against appellate was invalid as to all circumstances. Instead, he merely decided that based on the circumstances of the case in front of him, he could not determine whether or not the order clearly and specifically prohibited appellant's conduct. And as the previous argument has shown, and the court has noted, the specific facts of the case were very important to Judge Kroll when he was making that decision. As people have noted, he talks about the location that appellant was found. He talks about like various things that have to do with those facts. And I want to point out also that Judge Kroll is very clearly, when he is delivering his verdict, he at a couple points looks at the order and he reads it from it. And he reads out, and it says that the appellant is to stay away from the, let me get this precisely right, all property, grounds, and facilities at the Anacostia Metro Station and then at the address. And Judge Kroll does say it's a vast area, and he later says it's a large area, but he never expresses any concern over what that means. He never says, I don't know what area this is. I don't know what this is talking about. And that comes into light in the very end or near the end of his verdict, where he says, if the stay away was trying to keep him from the entire area, that would be, it said so, but then it provided a carve out. And so he acknowledges that the stay away order does in fact order him away from that entire area. I think that what Judge Kroll is doing here is that he's got evidence before him that the defendant, that the appellant could have been taking a bus or a train, or at least an argument that he is. And he's got a location across the street from all these buses, which he says, where the appellant could have been doing that. And absent any other evidence that his intent is not to do so, and absent any further information in the order itself, he can't make the conclusion that appellant wasn't there to take a bus or a train, and therefore finds him not guilty.
What language specifically are you relying on for the point you just made?
I'm talking about where he talks about, he says that it's a large area. Again, he says it's a large area, and if the stay away was trying to keep him from the entire area, that would be, it said so, but then it provided a carve out, which ostensibly the defendant could have been there taking a bus. And if it wanted to allow him to take a bus or a train station, it could have provided him a very specific guide to do so. And so I think that the collection of that is that he's working through, okay, what does the stay away say? It says that he's supposed to stay away from the entire area, but then it provides a carve out, and he could have been there to take a bus or a train. I don't have any other information saying one way or the other. So
who has the burden of proof? to establish or disestablish the exception for taking a bus or a train?
So,
Would
so
that
I
be
think,
something that- if the government were bringing this prosecution under this order, as you interpret it, in other words, assume there's no collateral estoppel bar, who would have the burden of proof with respect to proving whether he was or was not there to take a bus or a train?
so I think that at trial, I mean, in this case, for example, at trial, it's the government's burden to prove beyond a reasonable doubt that appellant did something to violate the order. And when the order says that if his intention to be there is to take a bus or a train, the government has to prove that that's not the case.
That was my understanding too.
Yeah.
So Judge Carl did not ground his decision on a finding that the government had failed to meet its burden of proving that he wasn't there to take a bus or a train.
So I think that Judge Kroll is struggling with that the entire time, because he mentions where appellant is and specifically says that he's across the street from all these buses. And he's talking about the carve out, primarily about the carve out. And I think that he's struggling with whether or not appellant is there to take a bus or a train. That's what his verdict decides on. I think that is the primary fact that he finds in his verdict, and that's the reason why he acquits appellant. I think that the court's right to point out that, look, Judge Crowell doesn't seem to think that nobody argues. In fact, appellant does not argue at trial. The court does not say anything about how the order is not specific as to the train station
I
itself.
mean, if you're, not to interrupt you, but if your interpretation is correct, then Judge Crowell said a lot of things that are completely unnecessary, extraneous.
And I think that
Comments about the scope of the order and it could have done this and it could have done that. All that's irrelevant if his finding really is, at the end of the day, the government simply didn't meet its burden of proving that he was there for a proper purpose.
And I think that he also,
Which is not what it says either.
I think that no matter,
in so many words.
I think you're right, Your Honor. I think that there's no interpretation of Judge Kroll's verdict that doesn't bring the person to conclude that he may have said some extraneous things.
Well, one concern I've had, you see, is that Judge Kroll's statement is not exactly a model of clarity. And it to the extent that we think it is ambiguous as to just what finding he is making, I'm wondering whether the doctrine of collateral estoppel can be invoked.
And I think that this might be because, as Judge Kroll notes, on page 114, but right before he gives his verdict, he says, usually I take some time and think about it and write something out. But I'm not doing that today because we've been at this for a long time. And so I do believe, Your Honor, that the doctrine shouldn't apply in cases where the judge's verdict is ambiguous. And the burden is on the defendant or on appellant to prove that this fact that he's trying to collaterally estop was necessarily decided. And
Now, you see,
in
on
cases,
another, I'm sorry, I apologize. Go ahead.
I just wanted to point out that in cases where it's the jury making the fact-finding decision, if it's at all ambiguous as to what the jury may or may not have found, collateral estoppel does not apply. And that's how that's set up. But go ahead, Your Honor.
Let me ask you about this. We've talked a lot about the facts. Suppose in the indictment, it's really not very clear whether or not this is or is not factually similar to the previous case, so that the finding applies. But during the course of the trial, it turns out, by golly, this is exactly the same kind of problem. Is it too late at that point to raise a double jeopardy collateral estoppel argument? I mean, wait until the government makes its case and then you raise it? Or is it always made?
So I think traditionally the claim is made pretrial because it's a double jeopardy claim, because it says, you're trying to prevent being tried at all. But I do think that in many circumstances, the case is tried, a conviction occurs, and then the case is appealed on collateral estoppel grounds. For example, in I think it's Thomas, there's a first trial for ADW. There's a second trial for unlawful possession of a firearm, and in Thomas, the court reverses the conviction for unlawful possession in the second trial because the acquittal for assault for a dangerous weapon from the first trial, there was evidence introduced that the defendant possessed the firearm doing the same things that he was acquitted for in the first case. And this sort of speaks to the strangeness of applying collateral estoppel at all in cases where it's a different set of factual circumstances, because in most of the cases it is that they're retrying the defendant for the same incident, at least, as opposed to a completely different incident with a completely different set of facts, different time, place, etc.
The double jeopardy and collateral estoppel are really doctrinally quite distinct, right? I mean, they overlap, but the government can be collaterally stopped where there's no double jeopardy.
That's correct, Your Honor.
Yeah.
I do think that they are, in fact, they're both rooted in the same clause of the amendment, but they are, in fact, fairly different.
Suppose we think that the proper reading of this Judge Kroll's holding, taking it in context, is that he is saying, look, to the extent that this stay away order tells him to stay out of the station, it's clear. There's no ambiguity about that. But to the extent it tells him to stay in a nebulous way away from the grounds and area of the station and so forth, it simply is not, quote, sufficiently clear and specific to serve as a guide for where he can and cannot go for his conduct. If that's our reading of this, where does that leave the current three counts, in your view?
So if the finding that Judge Kroll makes is that the order is ambiguous on its face as to the appellant's presence outside the station, I think for certain the first pending case, the one from July where he is inside the station, he actually leaves when the police tell him to leave, and then he comes back inside the station. I think that case is clearly not collaterally stopped. I think that if the court believes that Judge Crowell's finding is divorced from any of the factual circumstances of the first case, that it is purely an interpretation of the order, then I think the other cases would be collaterally stopped because they occur outside the train station, at least that the record we have before us has.
Is there any material difference between the locations at which he was found in these two cases these two newer cases from the location that he was found at in this case before Judge Kroll?
So I think that question, Your Honor, I won't be able to answer it, but that highlights the reason why collateral estoppel shouldn't apply. And
So
it's
it might
because
not, depends on what Judge Kroll was saying.
well, correct, Your Honor, but I think it's because that the sort of short summary of the facts that we have from those cases are what the government's put in its pleadings below. They haven't been litigated yet. So we don't actually know for sure. There hasn't been any testimony or any evidence about where exactly appellant was and what he was doing. And those circumstances could be very different from the ones that are in the first trial. They could be somewhat different.
Although
And
you would think that if the government, which obviously knows what evidence it intends to put on, thinks they are materially different, then it would have proffered that as part of the argument against applying collateral estoppel.
I think that's right. Although, it is appellant's burden, right, to prove that it was necessary, these facts were necessarily decided. And you'd think that appellant, having the discovery that he does in those cases, might also point out things that are similar between that case and these pending cases. And so I don't think that I don't think that you can hold that against the government in particular, because again, it is appellant's burden to show that that fact was necessarily decided. If there are no further questions, I'd ask the court affirm the decision of the Superior Court. Thank you.
Thank you. Mr. Schwartz, we give you 3 minutes. Mr. Schwartz, I think you have your mute on.
Thank you, Your Honor. I'll just start by saying and addressing this question of what's ambiguous, if anything, in Judge Kroll's factual finding. And I would start with, it's certainly not ambiguous that Judge Kroll starts by saying that he was troubled by and frankly cannot find beyond a reasonable doubt that the order is sufficiently clear and specific to serve as a guide for the defendant's conduct. And just to talk about the two cases that have conduct solely outside of the physical train station. Because to talk about if anything was ambiguous about Judge Kroll's finding, I'm sorry, to make clear that what's not ambiguous for certain is that Judge Kroll was concerned about inside versus outside the station. And when he said that the area Mr. Connor was found in was not the train station itself, it was not the actual metro. What else could that mean other than that Mr. Connor was outside of the physical train station? And I just emphasize that because there was no argument anywhere or no finding that Mr. Connor was not on actual metro property, that he was not in this large transportation campus area. And there was no testimony, no argument by either counsel that Mr. Connor was on some faraway sidewalk, and that the issue was whether the street itself was technically on metro property or technically wasn't. It was clear that Mr. Connor, and it was conceded that he was on undoubtedly metro-owned property. So when Judge Kroll said that Mr. Connor was not, when he was not the actual, where he was found was not the actual metro, it's clear that his issue was this term Anacostia Metro Station, unclear for inside versus outside. And all that supports that is talking about the lack of a map and calling this area a vast area. And so I say that as to the two cases that involve the fundamental question of inside versus outside. And the third case I return to when Judge Kroll talked about the stay away order not providing a guide of how he was to conform his behavior, basically saying that if it wanted to allow him to take a bus or train, it could have provided him a very specific guide to do so. And I put forward to the court, that argument is clearly separate from the inside versus outside piece. Clear that Judge Kroll is concerned there with this stay away order not being clear on what Mr. Connor is allowed to do present there. And
I don't understand this really when I think about it. Double jeopardy. You've been tried for murder of X, and they want to try you for murder of X the second time. Okay, that's being tried for the same crime. Why is double jeopardy relevant in a situation where you're being tried for a different crime? Same crime, but a different event. Same third time, same fourth time. We're arguing about what exactly the findings were in the first trial. It seems to me that the only real issue is collateral estoppel, not double jeopardy, unless I don't understand the double jeopardy. But to say that he's being tried, for, it's like you murder X and then the next day you murder Y. Well, just because you were acquitted of X doesn't mean you can go for Y. So we keep talking about what did the trial court really decide? Why is that a double jeopardy problem? Why isn't it?
And Your Honor, I would say that I look to the Supreme Court's language in Yeager, where it said, in Ash, we squarely held the double jeopardy clause precludes the government from relitigating any issue that was necessarily decided by a jury's acquittal in a prior trial. And so all collateral estoppel comes down to is whether there is a shared issue between the December 18th trial and these cases. And the shared issue is whether the March 25th stay away order is sufficiently clear and specific to serve as a guide for Mr. Connor's conduct. And as our brief and the arguments put forth, it is a shared issue. It was decided by Judge Kroll that it wasn't sufficiently clear and specific beyond a reasonable doubt, and therefore the government is stopped in relitigating these three cases. It does not have any effect on any future prosecution related to different stay away orders of Mr. Connor. It doesn't have any effect on future prosecution of this identical stay away order and other defendants. It only applies between Mr. Connor and the government in this very specific issue.
Whether we call it a cat or a dog, win. Collateral estoppel, you're gonna win. That's my problem. Talking about double jeopardy, but I understand what you're saying in the Supreme Court. Okay. Makes it a constitutional issue instead of a trial.
Yeah. Yes, Your Honor. As a matter of, I think the Supreme Court has started using the term issue preclusion to separate it from common law collateral estoppel, but it is a separate concept from common law collateral estoppel principles. And so if there are no further questions, I would just say that we request that the court reverse your court's denial of Mr. Connor's motion.
Thank you, counsel. The case is submitted, and we'll call the next case.
Bringing in the next case, Judge.
Yes, but, go ahead. Shall I call it now?
Yes.
Okay. Calling the third case on the calendar, Davon Holmes versus United States.
Counsel, you ready?
Yes, Your Honor.
Okay, Mr. Seligman, you may proceed. We have called the case, Mr. Seligman. You may proceed.
Okay.
You may proceed, Mr. Seligman. We'll hear you.
Thank you, Your Honor. On behalf of the appellant, Davon Holmes, it's the appellant's position that the trial court was incorrect when it, following the hearing on ineffective assistance of counsel, it determined that there was no deficient performance by the defense counsel and there was no prejudice. In finding that there was no deficient performance, the trial court erroneously relied on the defense counsel's assertion that the defendant had only asserted that he wanted to pursue a defense of the fact that he was not there, not present at the time. And that drove the court's evaluations from there on in. But at the hearing, it was clear that defense counsel acknowledged that he never even discussed the issue of self-defense as a possible defense in context to this case. Self-defense was really probably the only viable defense for the defendant, because the evidence was pretty overwhelming in terms of the witnesses. The defendant was present. One of the witnesses, two of the witnesses knew the defendant. One claimed he knew him pretty well. So it was pretty difficult to establish that he wasn't there. The other aspect of the defense that the defense counsel said he was pursuing was the defense of just challenging the witnesses and their credibility. The reality was that that was sort of a lazy way to approach trying this case. He acknowledged he did no investigation into self-defense. In fact, there was really no investigation, period, other than his attempting to confirm an alibi defense, which he talked to the wife of the defendant and then rejected that as a viable defense. So the obligations of counsel are clear. The case law in the Supreme Court and this court in Casio is that there's an obligation to do an investigation, and one cannot establish a trial strategy without doing a reasonable investigation. And in this situation, there was a possibility of raising self-defense. The defendant testified at the 23-110 hearing that had defense counsel brought up self-defense as an option, he would have agreed to that defense, and he would have testified, and he proffered then what his testimony would have been. And his testimony would have been essentially that he was with some friends standing by a fence and was approached by the decedent in an aggressive fashion. The decedent pushed him. There was pushing back and forth, and then there was an argument, and then the defendant perceived the decedent was reaching for a gun, and having known the decedent and known of his reputation as a stick-up kid, as he described it, he was fearful at that point that he would be shot.
Mr. Seligman,
And
question.
go ahead.
Mr. Seligman,
Yes.
your argument that if defense counsel says to a client, tell me what happened, and he says, I was never there. I was there, but I had nothing to do with the incident. I was there to visit my person. That's what happened. It's like an obligation to say, well, actually, we could concoct a pretty good defense by claiming that you were there and self-defense. And we can do an autopsy on the guy and we can find that he stole the drugs. So why don't we follow that route, and I'll put you on the stand and you can give a self-defense argument. Is that your argument?
No, my argument is that the defense counsel has an obligation to look at the case and investigate the case. And it's not his job to just take at face value, certainly at the outset, what a defendant tells him. It's his obligation to assess what the defendant tells him, and whether that's a realistic defense. And whether that's and whether that's believable under the circumstances in terms of what's going on, and advise his client as such. And that may take various forms. But one of the forms is to look at the evidence that's out there, and that evidence that was out there.
He put his client on the stand to give a story that is contrary to what the client told him actually happened. And what's more, come into a 23-110 and say, well, counsel should have come up with this defense, even though it's contrary to what I told him actually.
It's not counsel who's necessary. You're assuming, Your Honor, that counsel put words in his mouth. And that's not necessarily so. The counsel, I'm sure that counsel in 23-110 proceedings wouldn't have done that either. What typically happens in these cases is defendant gives a general denial. I wasn't there. I don't know anything. And that's common practice. As the case goes on, the defendant may change his story as to what, oh, well, I was there, and then gives more information. Or they may not. In this case, if he was pressed with the fact that his denial of being there was not believable, okay, then defense counsel isn't having him make up a story. He asks what really happened, or, you know, the situation looks like there's pushing back and forth. What really happened? What caused that pushing? Why did he approach you? Was there an argument? And then there's questions that are put to him that he says, look, this is a case, there's different kinds of defenses that can be brought. Yes, you can be in a defense you weren't there, but you can also bring a defense if the facts are true that that you were there, but something else happened in the course of this, and you were acting when you swung at him with your hand, you were acting in self-defense.
You
Tell
know,
me what.
like,
I don't think that that's making up a story.
are there handbooks for defense counsel, anything like that, deal with the issue of what do you do when a client tells you X, Y, Z, and you don't really believe them? You can think of a much better defense that can be raised, and therefore you have the obligation to investigate that defense, even though it depends upon a story which is contrary to what your client is telling you. I'm just curious, because honestly, I mean, I see your point. It sounds like it would have been a pretty good defense, potentially, but I
Well,
just,
Your Honor,
it sort of strikes me as correct.
the same,
10, you can come in and say, yes, I told my client, I told my attorney X, but really he should have done Y, which was contrary to what I told him actually happened. This is something, I don't know, maybe yes, people can talk about it.
Your Honor, in this situation, you have the same situation when somebody changes their plea. They plead guilty. There's many times where they've said, I wasn't there, I wasn't there, I wasn't there. And then when it comes down to it, it's their benefit, and they realize it's in their benefit, and they say, I was there, and they plead guilty. This is really no different situation than that. And in this situation, if there wasn't a viable, if his story didn't provide a viable self-defense, then, defense counsel wouldn't have put it on. But in this situation, he should have put it on if this information was given to him or her by their client after a thorough discussion of what the pros and cons of the case were, what the government's evidence was, and what evidence may go to a different defense. In this case, there was evidence that the decedent may have had a gun, and So that was something to be considered. There was evidence that there was pushing. There was evidence that the decedent was the aggressor, that he came to the defendant, not the other way around. So you had the situation that appears to an objective observer that there's a basis for asserting self-defense depending on other circumstances. And he needed more information. So a competent attorney in these situations would ask, what were these other situations, and tell them.
Mr. Seligman, the trial judge made a variety of factual findings, credibility findings. Are there any particular factual findings that you think were clearly erroneous?
Well,
I mean, the trial judge found as a fact that contrary to Mr. Holmes's testimony at the hearing, defense counsel did ask him what happened. They met several times. Defense counsel discussed the evidence with him. I don't know that you've identified any factual findings by the trial judge that can't stand up on appeal. If you have, I'd like to know about that.
well, the fact that he asked him what happened, and he told him, and his client told him one or more times a story that wasn't consistent with the evidence that was overwhelming against him, should not preclude him from continuing to investigate his case and follow up on possible leads that are there.
Well, you haven't identified any other investigation apart from speaking with the client that would have established a self-defense case.
Well, one of the major things is with the client. What else happened? What you're saying doesn't.
Well, we don't know that counsel didn't ask him about what happened.
Oh,
The problem you have is that you're now saying that the client basically lied to counsel and forced counsel to go to trial with a defense that was not particularly good. But for counsel to take issue with the client and suggest a different defense, that would have been pretty shaky too. It would have been a dicey situation, if they went to trial with a self-defense claim and lost, we might be hearing from the defendant saying, I have a different 23-110 motion. This motion is based on my counsel's foisting on me a false defense that was contrary to what I told him originally. And rather than pursue my true defense, which was I wasn't there. There's some consequences from counsel, from a client telling lies to one's counsel,
Well, that's true. And to some extent, they have to, under some circumstances, they have to accept it. But you have here the admission by defense counsel that the discussion of self-defense never occurred. It never left his lips the entire time. So, and that he met with the defendant twice only in a serious case like this. That's
not my recollection. My recollection is that there were more than 2 meetings.
Well,
am I mistaken about that?
I believe so. I don't want to contradict Your Honor, but my recollection is.
Feel free, but if I'm wrong.
At the hearing, basically, his excuse was, look, the defendant wants to. I have this. What does he refer to it as? There's a sort of catchphrase he uses: client-centered approach. So the defendant wants to do it. I do it. That's not exercising his professional obligation and duty to make an assessment of the case and give advice to the client.
Well, let me ask you this, before you sit down, let me just ask you, the trial judge also found that there was no reasonable probability that a self-defense defense would have led to a different outcome at this trial. Do you want to speak briefly to that?
Well, yes, I do. I think that the judge incorrectly found that she couldn't give instruction on self-defense, that there wasn't enough evidence to do that, even with his statement, even if the statement was presented to the jury as he testified. And I think that's clearly wrong, that the court had to give the sort of benefit of the doubt to the defendants in terms of whether to give an instruction. And there was nothing like some of the other cases where there were facts that would preclude on the face of it a self-defense. There wasn't him failing to retreat or retreating and coming back as in the other cases, whether it was the Smith case that was cited in the briefs. This case was unlike that. So the facts that were presented were, and the judge's conclusion as to what effect that would have had on the jury is something de novo for this court. The judge's, that wasn't a factual finding, that was a conclusion in terms of applying the Strickland standard. So under the Strickland standard, we would submit that the failure to exercise his duty and discuss available defenses undermined his ability to assert his Fifth Amendment right to testify, present a self-defense, which would have gone to the jury. And under those circumstances, the court confidence in the outcome of this case should be undermined. And that's the standard under Strickland that the court I would ask to apply. And under
Counsel,
that
can I? Oh, sorry, I didn't mean to interrupt you.
I think I've pretty much said it.
Okay. I just wanted to ask you this brief question. In your discussion of the various omissions by counsel that you say were prejudicial, you mentioned a number of times the lottery tickets and the sister's car. And I haven't been able to figure out why anybody thinks those were prejudicial, the fact that they came in. I'm not even sure I understand what was supposedly shown by this evidence. Can you just quickly explain?
Well, I think the government's theory was the lottery tickets suggest, because there were lottery tickets found at his house during a search, and they were also found, some lottery tickets were found on the scene of the crime, that was an indication he was present.
I mean, were the serial numbers in sync or something? Were they?
No, they weren't, and that was the argument as to why they weren't sufficiently relevant to come in, and any prejudicial value outweighed its probative value. And but also really the more concern was the knives and the box cutters. But the court's earlier.
What about the sister's car?
Oh, I'm sorry. Sister's car was to suggest that he was there and he had a getaway set up somehow. And that was the inference I think the government was trying to draw from it. And being that there was inconsistency in terms of the identification of that car, and the sister testified that the car wasn't available, that she was working that night, that it was, that was also irrelevant, and it wasn't sufficient evidence to establish that the defendant was there and involved in a getaway.
Okay.
Okay.
Thank you.
Sounds like you probably wouldn't be making this argument if that was all there was. These are not the most prejudicial of things, it seems to me.
I would agree with that. And essentially the prejudice that we're asserting here is the denial of his right to bring a defense of self-defense.
I understand.
We'll give you a few minutes in rebuttal. Let us hear from the government.
Thank you.
Ms. Park.
Good morning, Your Honors. May it please the court, Ann Park on behalf of the United States. The trial court here expressly discredited appellant's testimony and her conclusion that appellant failed to establish that he was prejudiced by his counsel's alleged deficiency in failing to present a self-defense case was predicated on this credibility determination. To prevail on appeal, appellant would have to demonstrate that the trial court's credibility determinations and findings were clearly erroneous, which he cannot do. I'd like to emphasize here that the trial judge was the judge, Judge Beck, presided both over the trial and appellant's 23-110 hearing. So she was in the best position to assess what impact appellant's testimony at the 23-110 hearing, how the jury how it would influence the jury's verdict. And she determined that there was no reasonable probability after discrediting his testimony and looking at the trial evidence in this case, which had no evidence of self-defense, that there would be a difference in the outcome. And because, yes, Your Honor.
His entire testimony, was it her job to make a determination as to whether or not his story about his self-defense, or I thought what she just got was his story about what he had told his client, I mean, his counsel.
No, she discredited.
The trial judge can make a credibility finding as to whether or not certain testimony was or was not credible in deciding whether, saying the jury would not have believed this guy as to his self-defense. That's an issue that I think is always, it's not clear.
Your Honor, as a factual matter, I believe she did discredit both his testimony about his conversation with defense counsel, as well as his testimony about the events that occurred that night. She expressly says, I discredit both what he said about what happened that night and his conversation with defense counsel. Now, I think she had to make a credibility finding. Did Your Honor disagree with me as to the record? That was my understanding, and I'll try to pull up the site.
I was just questioning whether it's the proper role of a trial judge at 23-110.
Yes, I believe it is. I mean,
As to whether or not the jury would or would not believe it. I'm just not sure about that. But
Your Honor,
I do accept the fact that he totally disbelieved his testimony as to what was told to counsel, because that's certainly her role.
Your Honor, my understanding is the trial judge, in order to assess whether there was a reasonable probability that trial counsel's alleged error here, that is his failure to present a self-defense, would have resulted in a different outcome. She had to hear and assess the evidence that he claimed would support self-defense. And the only evidence he put forth is appellant's testimony. Appellant testified under oath at the hearing. She discredited substantively what he had to say about the versions of that night. And because she did so, she found that his testimony would not have been persuasive to the jury, and the jury would not have found him innocent or accepted his self-defense theory. And I think that's exactly what the trial court is supposed to do in these 23-110 hearing cases. It's a whole purpose of having an evidentiary hearing. She's not taking anything away from the jury. She has to determine how this jury would have been impacted by the defendant had he testified to self-defense, as he now claims.
Ms. Park, may I ask you about this? Because I have wondered a bit about this same question. Let's draw a distinction. It's one thing for the trial judge to say, all right, the defendant in the 23-110 hearing is saying certain things happened, but the overwhelming weight of the evidence at trial disproves those things. And I think, therefore, if all he has is his testimony that he's given me at the 23-110 hearing, there's no reasonable probability that it would have made a difference in the outcome. It's another thing for the trial judge to say he's not a credible witness. And I think the jury would have found him not to be a credible witness. So I'm not going to, so for that reason, I am concluding that there's no reasonable probability that his testimony would have made a difference to the outcome. It seems to me those may be two different things, and I think I share Judge Stedman's uncertainty about whether the latter sort of analysis is appropriate for the defendant in considering the defendant's testimony to the 23-110. I'm just uncertain, and I wonder if you'd comment on that, and if you could think of any case law that squarely addresses the issue.
Your Honor, I don't have any case law that squarely addresses the issue. Just in our brief, we cite to general cases about when there's a conflict in testimony or there's a conflict in the trial court is required to have an evidentiary hearing to assess credibility. It's usually defense counsel against trial counsel against the defendant or other witnesses that he's brought forward.
Right.
I don't have anything specific, but Your Honor, I would say in this case, the trial court, she discredited his testimony about the substance of the events, but she also pointed to the fact that there was overwhelming evidence based on the trial evidence itself, and that she did both. It's not like she just relied on appellant's testimony and discredited it and said, okay, so the jury would not have believed it, therefore there's no Strickland prejudice. She went through the evidence and detailed the strength of the evidence.
See, on this particular case, for example, there are some problems with that self-defense theory. Let's put it that way. Number one, the force seems radically excessive.
That's correct, Your Honor, as we argued.
No, number two, the theory of how he inflicted that force, namely that some sort of wire from a fence could have done this, is very difficult to understand and seems very improbable, at least to me, and could be a ground for consideration and say that just doesn't accord with the evidence of what happened to this victim. And so that's a reason too why there's no reasonable probability. But for the judge to go further and say, well, look, I'll believe if I believed you were telling the truth, then you'd have a good defense. But I don't believe you're telling the truth. That I want seems a little bit different somehow. Have I made that point clear enough? And that's what I've been, I think, and perhaps just stepping to, I've been wondering about.
You're saying that she made the extra step of
It's
expressing
that to the extent of relying on
versus
this perceived just general lack of credibility. Because the jury, his answer might be, well, look, the jury might think I'm credible.
Your Honor, and I would just note, I don't, the line seems to be fine. And I think in this particular, the facts of this particular case, as Your Honor mentioned, his testimony about what happened that night, to me, sounds inherently incredible. Just because the gash was a 7-inch gash that severed the complainant's trachea. It was a 1-inch deep. It was a completely open wound that was gushing blood. There's no way he accidentally kind of threw his hand with a 2-inch piece of wire that he was playing with and did that kind of damage. So maybe the court did not have to go that far and just compare the evidence which she heard of Halestock, the 2 eyewitnesses in Hill, look at the nature of the injury and the extent of the injury, and the fact that appellant walked scot-free. He was unscathed, hopped into a car and drove off the scene while the complainant bled to death on the scene. So she didn't have to take the extra step. I think the fact that she did is not problematic in the context of this particular case, just because you have the evidence of Halestock and Hill. And I would disagree with appellant's counsel when he says that there was evidence of self-defense. As far as I can see, there's no evidence that the complainant was armed. There's no evidence that the complainant struck, hit, or injured appellant in any way or threatened appellant in any way. And there's no evidence, that appellant was harmed. And you look at, as Your Honor pointed out, complainant's injury, which was so much more severe than his. There's just nothing on this record that could support a self-defense theory besides appellant's.
You say that, except the evidence would have been his own testimony. That's pretty powerful evidence. But I want to get back to this first prong of Strickland. Is it the position of the government? Do you agree that it is an obligation of defense counsel, having heard his client tell him or her what exactly happened, to nonetheless make an investigation as to other possible defenses, which would be contrary to what his client told him happened? Is that, if this were a malpractice case for a doctor or something like that, we'd probably say, well, isn't there some kind of standard that designates the duties of a doctor we would probably want to look at some learned, I don't know if these exist, I have no idea. Standard of ethics for defense counsel, or a study of what defense counsel's duties are. There's just this assertion that it's the duty of defense counsel to disregard the story told him by his client and pursue other possible defenses, which would be contrary to what his client has told him happened. Is that the government's position, that that is a part of the duty of defense counsel?
I don't think the duty of defense counsel is set forth in any black and white rules. Like, you have to do, if your client tells you something, you have to either believe him or reject it entirely. I think it depends on the circumstances of this of the particular case.
Is that counsel did not act in accordance with what reasonable counsel would be expected to do in a situation?
I think in this situation, counsel acted reasonably in not pursuing self-defense and not further investigating self-defense. And here's why. First of all, he did ask his client what happened, and he was told, the appellant was told, I was not there. And defense counsel testified that he actually asked him several times, and he continued to persist. So he has that information in front of him. Then he didn't just plainly accept it. He confronted appellant with the evidence that contradicted his claim that he was there, that he was not there. That is, he went over the cell phone records that placed appellant in the general area of the stabbing, and appellant explained it away by saying, look, my mom and my sister live in that neighborhood, so that explained it. He then confronted appellant with the two eyewitnesses, one of whom knew him quite well, who placed him on the scene. And he asked them, well, they saw you there. Why would they say they saw you there if you weren't there? And appellant stated that the eyewitnesses could have mistaken him for another person, another Jamaica, or they made up the story. Now, he also, trial counsel also reviewed the case files that he was given by Ms. Amato, appellant's previous trial counsel. And based on that review, trial counsel actually testified that he didn't have, or he didn't think he had sufficient evidence to put forth self-defense. There were no eyewitnesses that supported self-defense. And now you have appellant saying he's not there. Self-defense is one of these defenses that you really need your client on board. Oftentimes, or many times, you have to establish the defendant's subjective fear or subjective threat of imminent fear through defendant's own testimony. So he needs to be on board. He's faced with a situation where the trial evidence or the evidence that he's been provided does not support a theory of self-defense. Appellant is claiming and insisting that he's not present. At this point, I'm not sure what he's supposed to do. I think the problem is, as Judge Glickman alluded to, is this was a pretty strong case, a very strong case against appellant. Ms. Amato, his prior counsel, thought it would be very difficult to prevail at trial, so she urged him to plead guilty, which he did not want to do, and which is why Mr. Bean was retained in the first place. So you have a case where I think he didn't have very many viable defenses, affirmative defenses, very good options. And often when that's the case, you're left with, you have to put the government to its proof because it's the government's burden. And that's a path he chose. With regard to the facts of this case, I think that was utterly reasonable. That was reasonable. Sure, maybe he could have done some more. Yes, but was it constitutionally deficient given what he had? The government would respond no. And the point I want to make about the failure to investigate claim, I think it's more important, is, as your honors pointed out, when you were questioning appellant's counsel, he has yet to identify what evidence would have been attained had a proper investigation been done. So usually you would have Hailstock or Hill come in and say, well, we recant our testimony and here's what really happened, and in support of self-defense, or you find another witness in support of self-defense. All we have here is appellant's testimony, and there's no other evidence that was provided. So it's kind of hard to determine prejudice when there is no other facts that are given. And that's essentially what the trial court found as to the failure to investigate claims. She specifically ruled, look, he says the counsel should have investigated, but I don't know what he would have found had he investigated. And so I can't find prejudice under Strickland. And we would contend that that's the correct result. And as far as the presentation of the self-defense case, again, you had the strong evidence of no self-defense, and then you had appellant's testimony, which was just on its face inherently incredible. And given that, we would argue that there was no reasonable probability that the case would have been different, or the outcome would have been different. Your Honor, I can't hear you. I'm sorry for some reason.
I was saying, counsel, thank you. And we'll hear from Mr. Sullivan. We'll give you a couple minutes. Thank you.
I have to unmute can you hear me?
Yes.
Okay. I'd like to respond first to what your question was or statement was about the slashing and being that the severity of the injury was such that it was excessive under the circumstances. But I think, yeah, the facts as they came out is there was a single swipe. There wasn't anything to indicate that it was anything other than a single swipe by the defendant. And the defendants, certainly a jury could consider whether that would have caused the degree of injury, but the defendant testified that he didn't anticipate that kind of injury from what he was doing with defense. But we don't know what had the lawyer investigated it and talked to, gone a little bit further with the medical examiner, might well have been able to establish that this kind of injury was consistent with any sharp object. In fact, the government's, the instructions the court gave were that there was a sharp object they used, which was the weapon, the dangerous weapon. So, and there's in the record, there's a statement that there's a jagged edge to the injury. I think the assertion was that he was still alive and therefore was jagged edge. But the defense counsel also, during the 23-110 hearing, sort of said he was capable of basically analyzing the medical examiner's report without getting any assistance. And the same was true with the toxicology report. This is a part of the investigation that he couldn't have done. And and he ultimately did consult. He didn't consult, but evidence was put on of a toxicologist who said that the PCP that was present was a factor in whether the defendant, the decedent was aggressive and could be considered. And under this court's ruling in the Robinson case, which was cited in our reply, that certainly would have been admissible for the jury to consider as to whether it was common for people who are using PCP to act aggressively, to be in a bizarre manner, which there was evidence that this person did, both at the time of approaching him and then later in terms of his the actions after the injury, which is he was running around, he was making phone calls that were unrelated to trying to get help, and wanted to smoke a cigarette in the car. This was all testimony about him after the incident, which was, I think, supportive of the fact that he was substantially affected by the PCP. And so that would be relevant evidence that his investigation would have found that he didn't, in answer to your earlier question. So I think his failure to do that when that was something that was sort of jumping out in terms of the PCP usage, and on that issue, ultimately, I think the court's questions about the role of the judge in terms of assessing credibility are something that we, I believe, raised and said really the role is for the jury to assess the credibility of his statement. In this case, again, I think the ruling in the Smith case is a good example of where the appellate court can look at the evidence and say, even believing even if he testifies this way, the evidence is such that it would be he would be precluded from getting a instruction on self-defense. But in this case, I think it'd be very hard for the court not to give instruction on self-defense, given his testimony. And so the jury should have been allowed to assess that credibility. The court can certainly make the determination that not true, some of the things that were said between him and counsel in terms of preparation. But counsel admitted he never got into the issue of self-defense. And
I think we have your argument. Thank you. Counsel, thank you both. Case is submitted.
thank you.
This court is now adjourned.